So, what is a crime? It seems like such a simple question, doesn't it? But the answer, well, it's not just hiding in some dusty law book. It's actually a reflection of our society's deepest values, our biggest fears, and all our conflicts. Today, we're going to tear it all down and see what's really going on inside.
So, let's just ask it straight up. What is a crime? Your first thought is probably something that's against the law, or maybe something that hurts people, like theft or murder. And you'd be absolutely right, but that's not the whole story, not by a long shot. Let's test this out with a few tricky examples from England and Wales. Is it a crime to fail to rescue a stranger who's in danger? Believe it or not, usually no. What about lying about having a vasectomy to get someone's consent for sex? Nope, not a crime. Breaking one of those super confusing and always changing COVID rules? Yep, that was a crime. And possessing cannabis? Also a crime. So you can see the line between what's legal and what's illegal can get really messy, and it doesn't always line up with our gut feeling of what's right and wrong.
So, how are we going to make sense of all this? Well, here's our roadmap. We're going to start with this crime conundrum, then dive into the big theories behind it all, harm versus morality. After that, we'll start asking some tough questions about the law's neutrality, take a look at how the system actually works in practice, and finally, wrap it up by seeing the law for what it is, a system of choices.
All right, first up, the crime conundrum. At its very heart, defining what a crime is isn't just a technical thing. It's a full-on philosophical battle about what the law is even for.
And that brings us to section 2, the big theories. This whole battle of ideas really boils down to two heavyweight philosophies that have been shaping law for centuries. Should the law just be there to stop us from harming each other, or should it actually be enforcing a society's shared moral code?
This whole clash was famously thrashed out back in the 1960s. In one corner, you had the legal philosopher H.L.A. Hart championing the harm principle. Basically, the law should stay out of our business unless we're harming someone else. And in the other corner, you had Lord Devlin arguing for moralism, the idea that a shared morality is the very glue holding society together, and the law has a duty to enforce it. I mean, this is a tension that's still playing out today in debates about everything from drug laws to what we can say online. Now, Hart was really building on the work of the philosopher John Stuart Mill, who wrote this absolute classic line. This is pretty much the foundation of modern liberal law. Your right to swing your fist ends where my nose begins. It's a simple, powerful idea, and it clearly justifies laws against stuff like violence and theft.
But don't think for a second that moralism is ancient history. Oh no. This quote comes from a really famous case in 1994, where a group of gay men were convicted for sadomasochistic acts that they all consented to. The judges didn't really focus on harm, nobody had complained. Instead, they made a clear moral judgment. Lord Templeman's words show the court acting as a kind of guardian of public morality, even when it comes to what happens in the bedroom. So this all leads to a really crucial question, doesn't it? When we talk about harm and morality, are those ideas really applied neutrally? Or does the law end up serving the interests of certain groups more than others? Let's just look at the data for a second. According to UK government figures, if you're black, you are 9 times more likely to be stopped and searched by the police than if you're white. A statistic like that forces us to ask some really tough questions about whether the law in practice is truly objective or if it's got some serious institutional biases baked into it. And these biases can actually pile on top of each other. The legal scholar Kimberly Crenshaw gave this a name: intersectionality. The big idea here is that you can't understand the discrimination a black woman faces by just adding racism plus sexism together. It's more like they multiply, creating a unique kind of disadvantage that the legal system often just doesn't see. Feminist critiques take this whole idea even further. The scholar Nair Naffin points out that, let's be honest, criminal law is an overwhelmingly male world. Historically, men made the rules, and they're still the majority of offenders, police officers, and judges. This means the law itself is often built on values that are traditionally seen as male, which can make it blind to harms that are mostly experienced by women. And if you want to see what that looks like in real life, well, this chart of the judiciary in England and Wales kind of says it all. Now, things are getting better, but the people who are actually interpreting and applying the law are still not really a reflection of the society they serve. And that lack of diversity can mean a lack of different perspectives when it comes to making these huge legal decisions. Okay, so we've spent a lot of time on the why of criminal law. Now let's switch gears and get practical. Let's look at the how. What's the actual journey a case takes from an alleged crime all the way to a final verdict? So, to get a conviction, the prosecution has to prove two things beyond a reasonable doubt. First, the actus reus, which is just Latin for the guilty act, the physical thing that happened. And second, the mens rea, or the guilty mind, basically the mental state behind it. Was it intentional? Was it reckless? Think of it as the action and the intention. You pretty much always need both. The journey itself follows a pretty clear path. It all starts with a police investigation. If they gather enough evidence and believe the case should go to court, they hand it over to the Crown Prosecution Service, or the CPS. Now, the CPS is independent. They look at the evidence and decide two things. Is there a realistic chance of getting a conviction? And is it in the public interest to even bring a case? If the answer is yes to both, then it's on to trial. And where that trial happens all depends on how serious the crime is. As you can see here, the system breaks it down into three basic tiers. Minor offenses, called summary offenses like a low-level assault, are handled in a magistrate's court. The most serious ones, indictable offenses like murder or rape, have to go to the Crown Court for a full trial by judge and jury. And then you've got this middle category of either-way offenses, like theft, which could end up in either court depending on the specifics. So, after all that, let's go back to our big question. What is criminal law? Well, it's not some static set of rules carved in stone. It's a living, breathing system that's constantly evolving. And it's built on a whole series of choices, conscious and sometimes unconscious, choices about what we value, what we're afraid of, and ultimately, who we decide to punish. The UK's very first female Supreme Court president, Lady Hale, just puts it perfectly. For a legal system to have any claim to being fair, the people making these life-changing decisions have to reflect the society they're serving. It's simple, really. Diverse experiences lead to a more nuanced and, hopefully, a more just understanding of the law. And that leaves us with one last thing to think about. We started by asking, what is a crime? But maybe, just maybe, the better question is this. If the criminal law really is a mirror reflecting our society's values, what do the choices we make about harm, about morality, and about justice, what do they truly say about who we are?